This video is a lot more about the exposure you can face for tax crimes than what a tax attorney can do to minimize that exposure, but let's go through some of the minimization steps an attorney can take. If you are charged with a tax crime, there's one element of a tax crime that is usually the hardest for the government to prove, and this is the element that most tax attorneys will spend as much time and energy as possible trying to undermine. That is the element of willfulness. It's ordinarily easy to obtain evidence on every element of a tax crime except what you were thinking when that tax crime was occurring. Negligence and willful actions can look a lot alike. The government doesn't have a jack that they can shove in the back of your head like in the Matrix and determine what you were thinking when you signed a return under penalties of perjury, that it was true and correct. The reason this is so hard for them to prove is if a tax attorney is doing their job, there's usually no direct evidence of your intent to cheat. The only way they can get direct evidence is with the words that come out of your mouth. A confession is the strongest evidence they can get that you committed a tax crime. Because of this lack of direct evidence, the government is left to try to prove that a tax crime occurred through the use of circumstantial evidence. Circumstantial evidence is gathered in a bunch of manners, which we're going to discuss later on in this tape. One example would be keeping a double set of books. If the government can prove you kept a double set of books, one that told you what the true income was in your business, one where the income was purposely understated to support a tax return, that's pretty good evidence that you intended to commit tax fraud. For example, two things a defense attorney can do to try and undermine the government's case as to willfulness is to try and argue that your actions were caused by inadvertence or a misunderstanding of the law rather than a willful intent to evade taxes. A good tax attorney will not bring forth arguments against willfulness that won't be effective. Some of those are the following. To try and show that you disapproved with the law, therefore didn't comply with it, will be ineffectual. To argue that you disagreed with the law based on religious grounds will be ineffectual. Or to argue that you were facing a host of personal problems, therefore you didn't comply with the law, is usually not effectual. Willfulness is defined as an intentional violation of a known legal duty. It can be established in a criminal case in a variety of manners. One manner is the following. If it could be shown that you had a reckless disregard for the law, had no interest in complying with it, that'll be enough to establish willfulness. Courts have argued that a taxpayer's knowledge of the law is not limited to their actual knowledge, but includes a reckless disregard for a legal obligation, where it can be shown that the defendant knew of that law in some manner or another. For example, to prove that a taxpayer intended to evade tax, they need only show that a taxpayer had the specific intent to avoid a tax that they knew was owing. Similarly, to prove that a taxpayer willfully failed to file a tax return, all the government really has to show is that that taxpayer knew they had an obligation to file a return and they willfully failed to do so. In defining willfulness, federal courts are consistently these days stepping away from older explanations of willfulness where they said that you had a bad faith or an evil motive for doing what you did. Neither one of those is no longer required. All that's required is to show that there was an intentional violation of a known legal duty. I give a 2-hour lecture to tax attorneys and CPAs on the following subject, but it's important to bring out the basics here.